seas, from the brightest day, from the darkest night, from the sunny day. I hope you learn something. I hope you learn something. I hope you learn something from the stormy sea, from the brightest day, from the darkest night, from the sunny day.
Earlier, we were reading the affidavit from a particular detective from a particular law enforcement agency about a particular person who is pictured in the upper left, and his activities around that area for a certain time with certain people doing certain things. That was deemed not safe for YouTube by YouTube. They pulled it off. They pulled the live stream off. I didn't notice at first, even though Picasso Knows tried to warn me, because according to the dashboard, which you see here, I was still live. YouTube was lying to me. I was not still live. I had been taken down. That was a trick designed to keep me going and probably post the video and incriminate myself. Anyway, these motions, the last one we read was a motion for summary judgment from the Maxwell team to throw this defamation suit by Giuffre out of court. Giuffre said that Maxwell had defamed her by using her people to publish in several British newspapers and the BBC that she was lying about Maxwell being a procurer and the main conduit for girls into Epstein's circle. As we saw in the document we were reading when we got shut down, it seems that that was not the case in 2005 and 2006. However, Giuffre says she was recruited in 1999, 2000, right in there. So 5 years before. So the MO could have changed. And there is every indication that Ghislaine did, in fact, recruit Giuffre into Epstein's clutches. So that's what we're reading about. So what we have here is a declaration by one Laura A. Menninger in support of defendant's motion for summary judgment. And as I said, the defendant is Ghislaine Maxwell, and the plaintiff is Virginia Giuffre, whose married name is now Roberts. Let's get into it. I gotta take another drink. This dries me out. As you can see, I felt so bad about earlier that I even changed my shirt. I had to get that off me. That was pretty bad stuff. I, Laura A. Menninger, declare as follows. 1. I am an attorney at law duly licensed in the state of New York and admitted to practice in the United States District Court for the Southern District of New York. I am a member of the law firm Haddon, Morgan, and Foreman, P.C., counsel of record for defendant Ghislaine Maxwell in this action. I respectfully submit this declaration in support of Ms. Maxwell's motion for summary judgment. I won't be reading all the footnotes, just the ones that seem to be particularly pertinent, so I'm going to leave this one go. And the paragraphs are numbered, so I'm reading each number. 2. Attached as Exhibit A is a true and correct copy of an article by Sharon Churcher entitled, quote, Prince Andrew and the 17-year-old girl his sex offender flew to Britain to meet him, close quote. That's by the Daily Mail, dated March 2nd, 2011. 3. Attached as Exhibit B is a true and correct copy of an article by Sharon Churcher entitled, quote, Teenage girl recruited by pedophile Jeffrey Epstein reveals how she twice met Bill Clinton, close quote. That's the Daily Mail, dated March 5, 2011. 4. Attached as Exhibit C is a true and correct copy of a statement on behalf of Ms. Maxwell, dated March 9, 2011. 5. Attached as Exhibit D, okay, this is getting really, really boring. Basically, these are descriptions of exhibits that have been filed that are buoying the desire of Maxwell to have this defamation suit by Jeffrey thrown out of court before it gets to trial. So, okay, this is interesting. 38. Attached as Exhibit KK is a true and correct copy of the Billionaire Playboys Club book manuscript, designated by plaintiff as confidential under the protective order. That's bizarre. Okay, and there's your certificate of service. Now here are the exhibits. These are the articles. Here's Prince Andrew meeting Virginia, or 17-year-old Virginia? I thought her name was Victoria. No, it's Virginia. I'm sorry. But here he is in a picture with this girl. They call her new name is Virginia Roberts, as you can see here. It's Virginia Roberts, not Jeffrey. She's married, but she can say that she literally did meet Andrew. There's photographic evidence. So she was being flown around meeting princes. Why would he take a picture with this girl dressed up in what looks like leather pants, showing her midriff? What's going on here, Andrew? Weird. Yes, Virginia. I got that wrong, not Victoria. Here she is in jodhpurs, etc., in formal English riding gear at Epstein's Zorro Ranch in New Mexico in 2001. So there are various articles here that we're skimming through. They're all basically the same. Virginia claiming to meet different people. All right, let's back up here. I went too far. I can't hit the page buttons because if I hit page up or page down, it takes me to an entirely different area and really messes things up. All right, let's see. Make sure here. Crying out loud. This is Document Cloud. It is very difficult to navigate. If you do a search, it takes you to the text version of the okay, here we go. All right. Takes you to the text version of the document, not the actual document page. So all right, thought we'd gone through that. Again, I'm very sorry for the unprofessionalism here. I normally do better than this. Okay, here we go. Now, Jane Doe 1 and Jane Doe 2 versus the United States. This is a case that was filed in the Southern District of Florida that was seeking to overturn the Epstein sentence and ultimate conviction and sentencing, which was a slap on the wrist for his under his 2005-2006 investigation, where he was found guilty of I think one count of molestation of a child and one count of trafficking, and he was given an 18-month sentence. Sorry, 16-month sentence, of which he served 11, and only 1 day a week out of those 11 was he in jail for the entire day. Monday through Saturday, he was out of jail for 12 hours while he conducted his quote-unquote philanthropic business in a private audience where he was allowed to receive visitors, both male and female, behind closed doors, with his guards his, being outside and not knowing what was going on behind the door. He got special treatment in jail. His cell was never locked. He got special food. He had the wing to himself. He was basically treated like royalty, as opposed to an ephebophile. Am I saying that right? Ephebophile? Or is it a bebephile? I think it's a ephebophile. I don't like the term pedophile being thrown at Epstein, because he was not going after prepubescent children. He was going after post-pubescent children. That's an entirely different category. That is a ephebophile. I realize pedophile is easier, but it has an entirely different denotation, and I just don't think that's right. David, yeah, is downloading as a PDF. It depends on what version of Reader you have. If you're using Acrobat, updated versions, and I mean basically pay versions, will allow you to search and annotate and things like that. I have a Reader subscription. I pay a couple dollars every so often. It's very cheap, and it allows me to do such things. If you work with PDFs any more than rarely or infrequently, I recommend looking into it. It's worth the money. It really is. Okay, so anyway, Jane Doe and Jane Doe 1 were victims in the original Epstein case. And they were not notified of the sentencing and of Epstein after his trial, which is a violation of the, I believe it's the Comprehensive or Civil Victims' Rights Act. Civil or comprehensive? It's but it's known as CVRA for short. And like I say, Victims' Rights Act is the most important part of it. And under that act, any sex offender's victims are to be notified of his sentencing. So at least they'll know when this piece of dirt, male or female, is going to be getting out of jail, so they can adjust accordingly. They may move, they may change their name, whatever, to keep from being recontacted by him or her. Because remember, there are female sex offenders too. And they were not notified. Went right by. Hebephile and ephebophile. Okay, so he was an ephebophile. Okay. Hebephile 11 to 14, ephebophile 15 to 19. So he was definitely an ephebophile. Okay. Iron slippers, I believe there is also a provision for notification upon release. Absolutely. I don't know that for a fact, but from what I remember about such things, that is a requirement. Thank you. That's a very good catch. Well noted. But anyway, so they were not notified of the sentence, and they filed a lawsuit under CVRA against the Southern District of Florida, U.S. Attorney's Office, to overturn Epstein's sentence and to get him a proper trial with a real outcome, because they were not included in the action involved. So that's Jane Doe 1 and Jane Doe 2. There was, later on, a Jane Doe 3 and a Jane Doe 4. And if I'm getting my numbers right, Virginia Giuffre Roberts was Jane Doe number 4. Her action to be joined, she filed a joinder motion to be added to Jane Doe 1 and Jane Doe 1 and Jane Doe 2's action, was thrown out. And the circumstances of Jane Doe 4, Virginia's joinder motion, was entirely implausible, because she included great lurid details about what had allegedly happened to her while she was in the employ of Epstein, and none of that was necessary for the filing. It was completely beyond the pale, actually, and it did not look good for her lawyers, one of whom is named Cassell. I forget the other at the time, but did not look good for them. They also tried to file her as a Jane Doe in the document, but when they filed it in to the court, they used Virginia's real name, which some people read to mean that they wanted the press all over the story and all over Virginia, so she could promote herself and gain a lot of money by selling her story and photographs, as you saw, the photograph with Prince Andrew, selling that stuff to the newspapers for cold hard cash. The judge said it was impertinent, and there was another word he used, but basically the judge said, this is wrong, you shouldn't be doing this, I'm throwing you out. So now what we have is the joinder for Jane Doe and Jane Doe 3, I'm sorry, Jane Doe 3 and Jane Doe 4 to go into the CVRA lawsuit that Jane Doe 1 and Jane Doe 2 had started some years previously. Either as crime victim, not what I said, crime victim. Right, it's right here. Okay, let's get into it. Now, there may be sections of this that I can't read. We've already shown that lurid details are not allowed by YouTube, so I may have to skip some parts. I'll scroll by so you at a later date can freeze frame and read them yourselves. But I obviously, if it's something not safe for work, I won't be able to use it. Okay. Jane Doe 3 and Jane Doe 4's corrected motion pursuant to Rule 21 for joinder in action. Come now, Jane Doe number 3 and Jane Doe number 4, also referred to as the, quote, new victims, by and through undersigned counsel, to file this motion pursuant to Federal Rule of Civil Procedure 21 to join this action on the condition that they not relitigate any issues already litigated by Jane Doe 1 and Jane Doe 2, also referred to as the, quote, current victims. The new victims have suffered the same violations of their rights under the Crime Victims' Rights Act, or CVRA, as the current victims. Accordingly, they desire to join in this action to vindicate their rights as well. Because the new victims will not relitigate any issues previously litigated by the current victims, and because they are represented by the same legal counsel as the current victims, the government will not be prejudiced if the court grants the motion. The court may, quote, at any time, add new parties to the action. Accordingly, the court should grant the motion. And there's a footnote here. As minor victims of sexual offenses, Jane Doe 3 and Jane Doe 4 desire to proceed by way of pseudonym for the same reasons that Jane Doe 1 and Jane Doe 2 proceeded in this fashion. Counsel for the new victims have made their true identities known to the government. I'm sorry, I missed a factual background. As the court is aware, more than 6 years ago, Jane Doe 1 filed the present action against the government, alleging a violation of her rights under the CVRA 18 U.S.C. subparagraph 377(1), DE1. She alleged that Jeffrey Epstein had sexually abused her and that the United States had entered into a secret non-prosecution agreement regarding those crimes in violation of her rights. At the first court hearing on the case, the court allowed Jane Doe number 2 to also join the action. Both Jane Doe 1 and Jane Doe 2 specifically argued that the government had failed to protect their CVRA rights, inter alia, to confer to reasonable notice and to be treated with fairness. In response, the government argued that the CVRA rights did not apply to Jane Doe 1 and Jane Doe 2 because no federal charges had ever been filed against Jeffrey Epstein. As an aside, that is a very interesting rub to this case, no pun intended. Epstein was obviously investigated by Palm Beach police, and they wound up filing state charges, but the state's attorney for Florida threw the case into the federal prosecutor for Southern Florida, who was Costas at the time, former and now somewhat disgraced labor secretary under President Trump. And Costas was, what do I do with this? There's no federal charges. I can't go back and make up federal charges. This has been investigated and he's charged. I have no federal case here. This all happened inside the state of Florida. And so Costas said, okay, well, we'll just give him sentencing under the state for what they agreed to with Epstein under his plea agreement, but they also gave this huge swath of immunity to co-defendants and any possible co-defendants in the future, which was insane. And that's the real basis of the CVRA here, that this huge number of people who had abused these girls and could be found in the future to have abused these girls were given immunity, completely against their rights. To continue, the court has firmly rejected the United States position. In a detailed ruling, the court concluded that the CVRA extended rights to Jane Doe 1 and Jane Doe 2, even though federal charges were never filed. The court explained that because the NPA barred prosecution of crimes committed against them by Epstein, they had, quote, standing to assert violations of the CVRA rights. The court deferred ruling on whether the two victims would be entitled to relief pending development of a fuller evidentiary record. Two other victims, who are in many respects similarly situated to the current victims, now wish to join this action. The new victims joining at this stage will not cause any delay, and their joinder in this case is the most expeditious manner in which to pursue their rights. Because the background regarding their abuse is relevant to the court's assessment of whether to allow them to join, their circumstances are recounted here briefly. Jane Doe number 3's circumstances. As with Jane Doe 1 and Jane Doe 2, Jane Doe 3 was repeatedly sexually abused by Epstein. The government then concealed from Jane Doe 3 the existence of its NPA from Jane Doe 3 in violation of her rights under the CVRA. If allowed to join this action, Jane Doe 3 would prove the following. In 1999, Jane Doe 3 was approached by Ghislaine Maxwell, one of the main women whom Epstein used to procure underage girls for sexual activities and a primary co-conspirator in his sexual abuse and sex trafficking scheme. And again, in the 2005-2006 investigation, it was a different person entirely. Basically, a high school girl who had been recruited by, I believe, a woman named Kellen, one of Epstein's employees, to go out and procure girls from her high school, Royal Palm Beach High School in Palm Beach, Florida. And that's how that was working. And these were all for girls to work specifically at Epstein's house in Palm Beach. Jane Doe 4, in this case, Virginia Giuffre, has stated that she was flown all over the world to be pimped out by Epstein and Maxwell to various people, including Prince Andrew. And again, we have a picture of her with Prince Andrew, so we can at least prove they met. But it's one of the parts of the motion for summary judgment for the defendant, Maxwell, was that Maxwell's name never came up during the investigation during the 2005-2006 time frame. That in no way exonerates Maxwell from being a procurer for Epstein if she had stopped doing it after 2001-2002, when that time frame was being said to have included Maxwell. The girl said that. So that was a red herring, in my opinion. To continue. In fact, it became known to the government that Maxwell herself regularly participated in Epstein's sexual exploitation of minors, including Jane Doe number 3. Maxwell persuaded Jane Doe number 3, who was then 15 years old, to come to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other co-conspirators coerced dozens of other children, including Jane Doe 1 and Jane Doe 2. When Jane Doe 3 began giving Epstein a, quote, massage, Epstein and Maxwell turned it into a sexual encounter, as they had done with many other victims. Epstein then became enamored with Jane Doe 3, and with the assistance of Maxwell, converted her into what is commonly referred to as a sex slave. And the defense in their previous motions tried to split hairs very finely about the actual definition of sex slave. It's pretty pathetic, in my opinion. Epstein kept Jane Doe 3 as his sex slave from about 1999 through 2002, when she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. Okay, this reads then that Jane Doe 3 is Giuffre, because everything that was said previously coincides with this perfectly. So I have that wrong. Epstein is Jane Doe, or excuse me, Giuffre is Jane Doe 3. From 1999 through 2002, Epstein frequently sexually abused Jane Doe number 3, not only in West Palm Beach, but also in New York, New Mexico, the U.S. Virgin Islands, in international airspace, on his Epstein's private planes, and elsewhere. That's how it reads. Epstein also sexually trafficked the then minor Jane Doe, making her available for sex to politically connected and financially powerful people. Epstein's purposes in, quote, lending Jane Doe, along with other young girls, to such powerful people, why is this not saying Jane Doe 3? To such powerful people were to ingratiate himself with them for business, personal, political, and financial gain, as well as to obtain potential blackmail information. There has been a great deal of discussion as to how Epstein made his money in the first place. And there is scant evidence that his financial advising firm actually brought in the money that he claimed it did. In fact, it looked like he did pretty poorly for his investors. I haven't seen the figures myself. This is what I understand to be a fact. So that money was not available. It seems that, and this is inference, but still, it seems that Epstein's main source of income was blackmail. He was found to have had cameras all over his residences to potentially record his girls with these men that are being referenced here, or other men who may not be so high up in the social standing, but to blackmail them and to receive monies from them accordingly. His mansion in New York City, I believe it's a 3-story townhome, has been said to be worth anywhere from 56 to $100 million. I've heard 3 figures. Those are the 2 extremes. It was given to him. So there you go. To continue. One such powerful individual that Epstein forced then minor Jane Doe 3 to have sexual relations with was former Harvard Law professor Alan Dershowitz, a close friend of Epstein's and a well-known criminal defense attorney. For those of you too young to know, Dershowitz was part of the dream team that helped get O.J. Simpson acquitted of his murder charges of his ex-wife and Ron Goldman. I'm probably going to have to watch it here from now on. While she was a minor, not only in Florida, but also in private planes in New York, New Mexico, and the U.S. Virgin Islands. In addition to being a participant in the abuse of Jane Doe 3 and other minors, Dershowitz was an eyewitness to abuse of many other minors by Epstein and several of Epstein's co-conspirators. Dershowitz would later play a significant role in negotiating the NPA on Epstein's behalf. Indeed, Dershowitz helped negotiate an agreement that provided immunity from federal prosecution in the Southern District of Florida, not only to Epstein, but also to, quote, any potential co-conspirators of Epstein, unquote. Dershowitz's defense for this is it's a lawyer's job to do the best he can for his client. And so Dershowitz worked hard to get these provisions included in the plea agreement. It's the DA's fault for agreeing to them. They had an airtight case against Dershowitz. Excuse me, I'm very sorry. Not against Dershowitz. They had an airtight case against Epstein. And to allow Dershowitz to negotiate a complete blanket immunity agreement for everybody else is just unconscionable. Iron Slippers, I agree. I do hope they find the tapes and or the books on the blackmail. That would be wonderful. However, so much time has gone by since the FBI has finally raided Little St. James Island that so much material could have been smuggled out of there that there may be scant evidence left to glean. I believe the same was true of his New York townhome and his home in Palm Beach, West Palm Beach. We'll have to see. I know they had some stuff. I believe from his New York townhome, they did get quite a number of DVDs labeled girl with guy or girls with guy, things like that, as looking like potential blackmail material. Iron Slippers, the client was Epstein. Dershowitz was the lawyer, or one of the lawyers, I believe. Yeah, Epstein or I should say Dershowitz was working for Epstein. But I think what you're saying is, since Dershowitz basically got himself off, he could have been as much the client as Epstein. If that's what you're saying, sorry I got it wrong the first time. Um, it's hard to read and get the context right the first time, and I'm really bad at it. Oh, okay, that was unjust, but you know what? It actually makes perfect sense um, to say it the way you did. As I read it, it makes perfect sense. So you basically got a three-fer out of that one. All right, let's get back to this. Right here. Indeed, Dershowitz helped negotiate an agreement that provided immunity from federal prosecution in the Southern District of Florida, not only to Epstein, but also to, quote, any potential co-conspirators of Epstein, close quote. Thus, Dershowitz helped negotiate an agreement with the provision that provided protection for himself against criminal prosecution in Florida for abusing Jane Doe number 3. So like you said, Iron Slippers, who's the client again? Because this broad immunity would have been controversial if disclosed, Dershowitz, along with other members of Epstein's defense team, and the government tried to keep the immunity provision secret from all of Epstein's victims and the general public, even though such secrecy violated the Crime Victims' Rights Act. Ghislaine Maxwell was another person in Epstein's inner circle, and a co-conspirator in Epstein's sexual abuse. Real quickly, for those of you who weren't here yesterday, Ghislaine is a name of German origin that has also been used in France for children, although it's a fairly old name. It doesn't get used very often anymore. In the German definition, and it carried over into French, a Ghislaine was meant an offering, often to bring together families. And that offering could include a child. So for Ghislaine Maxwell to be accused of being a procurer for Jeffrey Epstein, and her name literally meaning offering of a child, that just blows my mind. Absolutely blows my mind. Hey, John. Is it safe? One of my favorite movies, Marathon Man. It's safe this time. Yeah, it's safe. You can keep your speakers on at work if you need to. I'm cutting out all the charged words. Back to Ghislaine. She was someone who consequently also appreciated the immunity granted by the NPA for the crimes she committed in Florida. In addition to participating in the abuse of Jane Doe 3 and others, Maxwell also took numerous detailed pictures of girls under the age of 18 involved in activities, including Jane Doe number 3. She shared these photographs, which constituted bad things under applicable federal laws with Epstein. The government is apparently aware of and in certain instances possesses some of these photographs. Perhaps even more important to her role in Epstein's abuse ring, Maxwell had direct connections to other powerful individuals with whom she could connect Epstein. For instance, one such powerful individual Epstein forced Jane Doe 3 to bump uglies with was a member of the British royal family, Prince Andrew, aka Duke of York. Jane Doe 3 was forced to have naughties with this prince while she was a minor in 3 separate geographical locations: in London, at Ghislaine Maxwell's apartment, in New York, and on Epstein's private island in the U.S. Virgin Islands. In a group with numerous other um, girls who are not of age. Epstein instructed Jane Doe number 3 that she was to give the prince things and required Jane Doe 3 to report back to him on what happened. Maxwell facilitated Prince Andrew's naughty things by acting as a madam for Epstein, thereby assisting in internationally trafficking Jane Doe 3 and numerous other girls for naughty things. This is ridiculous. Oh, Tiger threw a bogey. At least he made it up with the birdie. Good for him. So what? Is he still 2 under? 3 under now? Another person in Epstein's inner circle of friends, who becomes apparent with almost no investigative effort, is Jean-Luc Brunel. Epstein ran Jane Doe number 3 to Jean-Luc Brunel many times. Brunel was another of Epstein's closest friends and a regular traveling companion who had many contacts with young girls throughout the world. Brunel has been a model scout for various modeling agencies for many years and apparently was able to get U.S. passports for young girls to work as models. Work was in quotes. He would bring young girls, ranging to ages as young as 12, to the United States for naughty things and farm them out to his friends, especially Epstein. Brunel would offer the girls, quote, modeling jobs. Many of the girls came from poor countries or impoverished backgrounds, and he lured them in with the promise of making good money. That's typical grooming activity. And remember, as I said yesterday, trafficking is a very, very, very real thing in the United States right now. And the most often trafficked person is a boy age 9, usually white. If you want more information on this, please go to Fox Go. It doesn't work on Apple TV, the Fox app. You only get snippets of these shows. And I'm talking about Life, Liberty, and Levin, Mark Levin's show that's on Sunday nights, 9 o'clock Central Time. 2 weeks ago, he had on a trafficking expert, and it was quite disturbing. You need to watch it. You need to tell everyone to watch it. Look up the organization that he discusses with his guest and see what you can do to help them, even if it's just spread the word. Again, it was 2 weeks ago on Life, Liberty, and Levin, Sunday night on Fox. So find an app that lists the previous shows. You may be able to do it on your iPad or Chromecast, whatever, but it doesn't work on Apple TV. And watch that show. It's hard to watch. It's hard to watch. I'll leave it at that. Back to the text right here. Epstein forced Jane Doe 3 to observe him, Brunel, and Maxwell engage in wrong things with dozens of underage girls. Epstein also forced Jane Doe 3 to do something incorrect with Brunel, often, at places including Epstein's mansion in West Palm Beach, Little St. James Island in the U.S. Virgin Islands, including many group things that were comprised of other girls less than legal age, New York City, Mexico, Paris, the south of France, and California. Epstein also trafficked Jane Doe 3 for naughty purposes to many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. Epstein required Jane Doe 3 to describe the events she had with these men so that he could potentially blackmail them. Government was well aware of Jane Doe 3. Now again, this is Virginia Giuffre's attempt with another girl to achieve a joinder with the CVRA suit that Jane Doe 1 and Jane Doe 2 had filed some years previously. All of this is unnecessary to show cause to gain joinder in that case. All of it. The government was well aware of Jane Doe 3 when it was negotiating the NPA, as it listed her as a victim in the attachment to the NPA. Moreover, even a rudimentary investigation of Jane Doe 3's relationship to Epstein would have revealed the fact that she had been sent throughout the United States and internationally for wrong things. Nonetheless, the government secretly negotiated a non-prosecution agreement with Epstein, precluding any federal prosecution in the Southern District of Florida of Epstein and his co-conspirators. Okay, I got that wrong earlier. The reason Costas didn't take federal charges against Epstein is the plea agreement precluded that. That was my mistake. I apologize. Okay, we got it right at least, so good to know. As with Jane Doe 1 and Jane Doe 2, the government concealed the non-prosecution agreement from Jane Doe 3, all in violation of her rights under the CVRA, to avoid Jane Doe 3 from raising powerful objections to the NPA that would have shed tremendous public light on Epstein and other powerful individuals, and that would likely have been prevented it. That's what it says, would likely have been prevented it from being concluded in the secretive manner in which it was. Jane Doe 4's circumstances. If permitted, this ought to be interesting to see how it compares to Jane Doe 3. If permitted to join this action, Jane Doe 4 would allege and could prove at trial that she has CVRA claims similar to those advanced by Jane Doe 1 and Jane Doe 2 based on the following. As with the other Jane Does, Jane Doe 4 was repeatedly wronged by Epstein. In or around the summer of 2002, Jane Doe 4, an economically poor and vulnerable 16-year-old child, was told by another one of Epstein's underage victims that she could make $300 cash by giving an old man physical contact on Palm Beach. An acquaintance of Jane Doe 4, also a minor sexual abuse victim of Epstein, telephoned Epstein and scheduled Jane Doe 4 to go to Epstein's house to give him physical contact. During that call, Epstein himself got on the phone, a means of interstate communication, with Jane Doe 4, asking her personally to come to his mansion in Palm Beach. Jane Doe 4 then went to Epstein's mansion and was escorted upstairs to Epstein's large bathroom by one of Epstein's assistants. Shortly thereafter, Jeffrey Epstein emerged and lay face down on the table and told Jane Doe 4 to start having contact with him. Epstein asked Jane Doe 3 her age, and she told him she had recently turned 16. Epstein subsequently committed illegal acts against Jane Doe 4 on many occasions. Epstein used as a means of interstate communication, i.e. a cell phone, to arrange for these meetings. Epstein also frequently traveled in interstate commerce, i.e. on his personal jet, for purposes of illegally contacting Jane Doe 4. The acts Epstein committed against Jane Doe 4, again, this was filed by Castle and his partner, so they're going for it whole hog. As an aside, Alan Dershowitz has called Castle the most corrupt lawyer in America. And there is visible hatred in his voice and eyes when he says that. Tiger's still under 2 after 6. Now he's got to step it up a little bit. Sorry for the wind noise. It's a beautiful day out there and it's coming through the window. Let me know in the chat if it's too bothersome and I can close the window a bit. Just tag me, at AHNC. I'll have no cattle. Put that at in there and run it out, and I'll see it, and I'll follow your instructions. And if you need to get a hold of me at all in the chat, just do that at AHNC. It'll autofill, hit enter, and boom, it'll alert me that you're messaging me. Otherwise, you guys, you know what to do. You're veterans for chats. It's one of the best chats on YouTube, by the way. Thank you all for being here. I'm very impressed with the level of knowledge and maturity shown in this chat. Although y'all do have your fun, that's cool. The acts Epstein committed against Jane Doe 4 constituted numerous federal offenses, some of which... You're welcome, David. Thank you. Thank you. Can constitute numerous federal offenses, some of which do not carry a statute of limitations and thus are not time-barred. And these offenses were the kinds of offenses that the Federal Bureau of Investigation and the U.S. Attorney's Office for the Southern District of Florida were pursuing in 2007. So far as Jane Doe 4 is aware, the U.S. Attorney's Office made no serious effort to locate her. Instead, after identifying approximately 40 separate underage sexually abused victims, and apparently preparing a 53-page federal indictment, and with full awareness of the existence of many victims like Jane Doe number 4, unidentified and not interviewed, it entered into a non-prosecution agreement barring prosecution of Epstein's federal crimes against these victims. This is contrary to the government's normal approach in prosecuting federal offenses. It also violated Jane Doe number 4's rights under the CVRA, including the fact that she had had a reasonable, quote-unquote, right to confer with the U.S. Attorney's Office before they entered into an agreement with a sex offender barring prosecution of him for the crimes he committed against her. And that cites 18 U.S.C. Section 377 1A5 for you law nerds out there. Oh, while I'm thinking of it, let me bring it back up here. I want to let you know how to get a hold of that document we were looking at earlier. What you want to do is go to the Palm Beach Police Department webpage. There's a section there, I believe, called Documents. You can figure it out easily. And in that section, there is a request to show you how to do a FOIA. Here's what you want to reference to make it perfectly clear. I'm going to put it in the chat. It's police case. Where's my note? I'm so old I don't remember where the pound key is. See, I use pound key, not hashtag. Police case number 05368 parenthetical 1. So, go to the Palm Beach. Let's just see if I can pull it up right now. I'll show it to you. let's see. Yeah. This is my request number. Let me back up a bit. Okay, so go to Palm Beach, FL, justfoia.com. And just go to Palm Beach, just do an internet search for Palm Beach Police Department, and you'll get what you need. So do a public records request, and let's do a new request here, so I'll show you. And PZB records. I don't know what that means. Clerk public records request. Let me see here. Sorry it's taking so long, but okay, no, that's planning zone and building department. Okay, that's not right. So you would want to do a clerk public records request. And here is, you put in your name, phone number, email, your address, city, state, and zip, as it says, and then description of request, and just say that you are requesting the release of public case number 05-368, parenthetical 1. And you can also say this is the Epstein, the Jeffrey Epstein affidavit produced in 2006. I appreciate that Picasso knows, but it's too late. We already did it. It's already completely clear that I'm not going to be able to finish this before I leave town next week. So why bother, right? I'm going to be reading every day except Saturday. So, what the hell? Let's just make a day out of it. So anyway, that's all you have to do. And you will get the PDF. You'll get a link emailed to you, and you're rocking and rolling. Okay. Now, you'll notice that Jane Doe 4's motion for joinder, the inclusion in the joinder, was nowhere near as salacious as Jane Doe 3. That gave a lot of ammunition to Maxwell's lawyers in arguing against Jane Doe 3's credibility, saying that she's just in it for the money. But just because she wants to make money on it doesn't mean it didn't happen. Have to keep that in mind. It compromises her character, but not necessarily the facts. Motion for joinder. Jane Doe 3 and Jane Doe 4 now both move to join this action, followed by Jane Doe 1 and Jane Doe 2, pursuant to Rule 21 of the Federal Rules of Civil Procedure. Rule 21 provides that, on motion or on its own, the court may at any time, on just terms, add a party. Rule 21, quote, grants the court broad discretion to permit a change in the parties at any stage of the litigation, close quote. The new victims should be allowed to join the current victims in this action under Rule 21. The new victims will establish at trial that the government violated their CVRA rights in the same way as it violated the rights of other victims. The new victims' participation in this case is important because it appears that the government intends to raise a factual defense that somehow it did keep Jane Doe 1 and Jane Doe 2 properly informed of what was happening in the criminal prosecution. Of course, if 4 victims all testify consistently that they were not properly informed by the government, as we believe they will, that provides a stronger case for a CVRA violation. If you excuse me for a second, I have reached the end of my tea, and so I will communicate with my executive producer. and I believe she is off to the races. For those of you who are new, again, Picasso Knows is my executive producer and the love of my life. How could you not love someone who helps you as much as she does? To put it bluntly, I would be dead in a ditch if it wasn't for her. I mean that most sincerely. She has saved my life several times. Literally saved my life several times. To continue. In addition, Jane Doe 3 and Jane Doe 4's participation is relevant to a defense the court has allowed the government to raise. The court has previously ruled that the victim's request for rescission of the NPA, quote, implicates a fact-sensitive, equitable defense which must be considered in the historical factual context of the entire interface between Epstein, the relevant prosecutorial authorities, and the federal offense victims, including an assessment of the allegation of a deliberate conspiracy between Epstein and federal prosecutors to keep the victims in the dark on the pendency of negotiations between Epstein and federal authorities until well after the fact, and presentation of the non-prosecution agreement to them as a fait accompli, close quote. That was all one sentence, folks. All one sentence. Jane Doe 3 and Jane Doe 4's participation in this case will help to show what the, quote, entire interface was between the government and the victims, and thus to respond to the government's estoppel arguments as well as other defenses that it appears to be preparing to raise. Jane Doe 3's and Jane Doe 4's participation is also directly relevant to the discovery disputes currently pending in this case. The government has raised various relevancy objections to the documents that Jane Doe 1 and Jane Doe 2 are attempting to obtain. The current victims have responded by explaining how these documents are relevant, including explaining how these documents might bear on the way in which Epstein used his powerful political and social connections to secure a favorable plea deal, as well as provide proof of the government's motive to deliberately fail to investigate certain aspects of the victim's claims in an effort to maintain the secrecy of the facts and resolve the case without the victim's knowledge. Jane Doe 3 and Jane Doe 4's participation will help prove the relevancy of these requests, as well as the need for those requests. Excuse me just a second. I have to yell through the door. And that's taken care of. Oops, wrong section. Uh-oh. David says that Tiger's in trouble. Come on, Tiger. Hang in there. I love that man, but he just hasn't been the same after the divorce. It really, really messed him up. It proves just how mental of a game golf is. How much of that is in your mind. Back to the text. One clear example is request for production number 8, which seeks documents regarding Epstein's lobbying efforts to persuade the government to give him a more favorable plea arrangement and or non-prosecution agreement, including efforts on his behalf by Prince Andrew and former Harvard Law professor Alan Dershowitz. Jane Doe 1 and Jane Doe 2 have alleged these materials are needed to prove their allegations that, after Epstein signed the non-prosecution agreement, his performance was delayed while he used his significant social and political connections to lobby the Justice Department to obtain a more favorable plea deal. Jane Doe 3 has directly personal knowledge of Epstein's connections with some of these powerful people, and thus how Epstein might have used them to secure favorable treatment. Excuse me again. Now we're cooking with gas. Continuing. Adding 2 new victims to this case will not delay any of the proceedings. They will simply join in motions that the current victims were going to file in any event. For example, new victims will simply join in a single summary judgment motion that the current victims anticipate filing after discovery has been completed. Nor will adding the new victims prejudice the United States. As the court is aware, this court is still in its initial discovery stage. The court is currently considering whether to reject the government's assertion of privilege over documents regarding the case. The new victims do not seek any additional discovery beyond that previously sought by the current victims. Accordingly, the United States will not be prejudiced or burdened by adding them to this case. See, this is all they had to put in there. The lurid details that Jane Doe 3, which is Virginia Giuffre, those that were included in her part of the motion were just scandalous, really scandalous. And deliberately so, in my opinion. The CVRA does not contain any statute of limitations for filing an action to enforce rights under the statute. Accordingly, were the court to deny this motion, the result might be that the new victims would then be forced to file a separate suit raising their claims, which would then possibly proceed on separate litigation track. Rather than require duplicative litigation, the court should simply grant their motion to join. There was the footnote, just a paragraph above. Footnote 2 says Jane Doe 3 and Jane Doe 4 have asked the government to provide them with the record of their statements that they provided to the FBI. These FBI 302s should only be a few pages long. Okay. Jane Doe 1 and Jane Doe 2 support the joinder motion. Counsel for the victims have discussed this motion with the government at length in an effort to avoid any need to file a substantive pleading on the issue. Counsel for the victims asked the government during the summer for its position on joinder. The government, however, took the matter under advisement for months. Ultimately, after several inquiries from victims' counsel, the government indicated without explanation that it opposes this motion. Counsel for the victims has requested a meeting with the government on this issue, which will hopefully occur in January. In the meantime, however, counsel for the victims believe that it is no longer appropriate to delay filing this motion and accordingly file it at this time. Because the government is apparently opposing this motion, Jane Doe 3 and Jane Doe 4 have described the circumstances surrounding their claims so that the court has appropriate information to rule on the issue. Laura, are you serious? 9 New York cops, we'll say allegedly suicided, just to be fair, 2 this week alone? Oh my God. Now you can see that, of course, as you put it, retribution for seeing Weiner's laptop and all of the Hillary emails that were contained on that. But it is also possible that the current atmosphere, the current anti-law enforcement atmosphere in New York City has contributed to some deep emotions that they've held in check until this time. To know that your city no longer supports you, that is a horrible burden to bear. And I don't know how I would deal with it, especially if I was a police officer, with the stress that is just part of the job, part and parcel. But I do see your point. I hope that's not the case. Oh, Laura, thank you for the back surgery. I'd completely forgotten about that. Yes, Tiger did have major back surgery. See, and that really screws up your swing if it's not done absolutely perfectly. You cannot get around your hips. You can't get your shoulders around your hips the way you need to. My lower spine is completely fused, so I had to give up the game. I was able to play even with my artificial hips, But once I lost the ability to bring my back around and bring my shoulders around, that was it for me. I was done. I still have my clubs. I can't give them up. But yeah, I'm out. I'm out. Okay, that's the motion. And there's a conclusion page here. Jane Doe 3 and Jane Doe 4 should be allowed to join this action pursuant to Rule 21 of the Federal Rules of Civil Procedure. Their joinder should be conditioned on the requirement that they not relitigate any issues previously litigated by Jane Doe 1 and Jane Doe 2. A proposed order to that effect is attached to this pleading. This is dated January 2, 2015. As I understand it, this is still the case regarding Epstein's plea deal, and the CVRA motion is still being adjudicated. Now, correct me if I'm wrong, folks. That's how I understand it. Sharon, you just had your entire spine fused? Do you have, what is it, condyloiditis? Or a condyle pathology to have that happen? I mean, you don't have to tell me. I'm sorry. That's a personal question. I apologize. It's none of my business. But that is a horrible situation. I pray for you. I seriously pray for you that you're able to recover and do as best you can. I have L1 through S1 fused, and C6 and C7 are fused. That one didn't work. I'm now on morphine for the pain caused by that screw up and the original pathology that went along with it, that supposedly required the fusion of those two vertebrae. Turned out it should have been the two vertebrae above it. Thanks a lot for that, doctor. Oh, good Lord. Yeah, you could probably build your own Iron Man suit out of the titanium that they've put into you. You could become Iron Man. Work on it. I remember the recovery for my back surgeries and my hips, but I didn't have all those done at the same time. And I assume you didn't either. I assume it went in stages. But still, man. Yes, God bless you, Sharon, and all the prayers that I can possibly muster. Picasso knows too. We'll send out to you. I pray your caregivers are able to keep up with you. I know how stressful that can be. Okay. United States District Court, Southern District of Florida, Jane Doe 1 and Jane Doe 2, petitioners versus United States of America, responded. Order denying petitioner's motion to join under Rule 21 and motion to amend under Rule 15. This cause is before the court on Jane Doe 3 and Jane Doe 4's corrected motion pursuant to Rule 21 for joinder in action, known as Rule 21 motion, and Jane Doe 1 and Jane Doe 2's protective motion pursuant to Rule 15 to amend their pleadings to conform to existing evidence and to add Jane Doe 3 and Jane Doe 4 as petitioners. Both motions are ripe for review. For the following reasons, the court concludes that they should be denied. So this is the result of what we just read before. Plus another motion that Jane Doe 1 and Jane Doe 2 had provided. Background. This is an action by two unnamed petitioners, Jane Doe 1 and Jane Doe 2, seeking to prosecute a claim under the Crime Victims' Rights Act, CVRA, and there's a citation. Generally, they allege that the respondent government violated their rights under the CVRA by failing to consult with them before negotiating a non-prosecution agreement with Jeffrey Epstein, who subjected them to various crimes while they were minors. Petitioners initiated this action in July 2008. On December 30, 2014, two other unnamed victims, Jane Doe 3 and Jane Doe 4, moved to join as petitioners in this action pursuant to Federal Rule of Civil Procedure 21. Petitioners, Jane Doe 1 and Jane Doe 2, support the Rule 21 motion. Jane Doe 3 and Jane Doe 4 argued that they, quote, have suffered the same violations of their rights under the CVRA as the, close quote, petitioners, and they, quote, desire to join in this action to vindicate their rights as well, close quote. The government vehemently opposes joinder under Rule 21. The government argues that Rule 15 is the proper procedural device for adding parties to an action, not Rule 21. Quote, out of an abundance of caution, close quote, petitioners filed a motion to amend their petition under Rule 15, conforming the petition to the evidence and adding Jane Doe 3 and Jane Doe 4 as petitioners. The government opposes the Rule 15 motion as well. Among other things, the government argues that amending the petition to include Jane Doe 3 and Jane Doe 4 should be denied because of their undue delay in seeking to join the proceedings and the undue prejudice that amendment will cause. After considering the parties' submissions and the proposed amended petition, the court finds that justice does not require amendment in this instance and exercises its discretion to deny the amendment. Discussion. The decision whether to grant leave to amend a complaint is within the sole discretion of the district court. That's a quote from Lorry versus Alabama Court Criminal Appeals. Quote, the court should freely give leave when justice so requires. There's a federal civil citation. Justice does not require several instances, quote, including undue delay, bad faith, dilatory motive on the part of the movant, undue prejudice to the opposing party by virtue of allowance of the amendment, and futility of the amendment, close quote. In addition to considering the effect of amendment on the parties, the court must consider, quote, the importance of the amendment on the proper determination of the merits of a dispute. Justice does not require amendment where the addition of parties with duplicative claims will not materially advance the resolution of the litigation on its merits. On the merits. Paragraph A, Rule 21 motion. This is under Section 2, by the way. Discussion. Paragraph A, Rule 21 motion. Jane Doe 3 and Jane Doe 4's first attempt to join this proceeding was brought under Rule 21. Quote, if parties seek to add a party under Rule 21, courts generally use the standard of Rule 15, governing amendments to pleadings, to determine whether to allow the addition, close quote. Lots of citations here. Okay, back to the next paragraph. Rule 21, quote, misjoinder and non-joinder of parties, close quote, provides the court with a tool for connecting the, quote, misjoinder of parties that would otherwise result in dismissal. Insofar as Rule 21, quote, relates to the addition of parties, it is intended to permit the bringing in of a person who, through inadvertence, mistake, or for some other reason, had not been made a party, and whose presence as a party is later found necessary or desirable. Close quote. In their Rule 21 motion, Jane Doe 3 and Jane Doe 4 do not claim they were omitted from this proceeding due to any, quote, inadvertence or, quote, mistake by petitioners. Rather, they seek to join this proceeding as parties that could have been permissively joined in the original petition under Rule 20, quote, permissive joinder of parties. As courts generally use the standards of Rule 15 to evaluate such circumstances, the court will consider the joinder issue as presented in the Rule 15 motion. The court will consider the arguments presented in the Rule 21 motion as if they are set forth in the Rule 15 motion as well. Because the arguments are presented in the Rule 15 motion, and because the court is denying the Rule 15 motion on its merits as discussed below, the Rule 21 motion will be denied. So, looks like Jane Doe 3 and Jane Doe 4 are out the door. The court also concludes that portions of the Rule 21 motion and related filings should be stricken from the record, as we discussed earlier. Should be stricken from the record. Pending for this court's consideration is a motion for limited intervention filed by Alan M. Dershowitz, who seeks to intervene to, quote, strike the outrageous and impertinent allegations made against him and to request a show cause order to the attorneys that have made them, close quote. Like I said, Dershowitz is mad as a nest of wet hornets when it comes to Castle and the other lawyer in this partnership, mainly Castle. The court has considered Mr. Dershowitz's arguments, but it finds that his intervention is unnecessary as Federal Rule of Civil Procedure 12F empowers the court, quote, on its own, to, quote, strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter, close quote. Petitioner's Rule 21 motion consists of relatively little argumentation regarding why the court should permit them to join in this action. They argue that 1, they were sexually abused, I read it, by Jeffrey Epstein, and 2, the government violated their CVRA rights by concealing the non-prosecution agreement with them. However, the bulk of the Rule 21 motion consists of copious factual details that Jane Doe 3 and Jane Doe 4, quote, would prove, unquote, quote, if allowed to join this action, unquote. Specifically, Jane Doe 3 proffers that she could prove the circumstances under which a non-party introduced her to Mr. Epstein and how Mr. Epstein moved her to several high-profile non-party individuals, quote, including numerous prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders, close quote. She names several individuals, and she offers details about the type of things performed and where they took place. Earlier yesterday, we were reading part of a deposition that was given by Jane Doe 3, or Virginia Giuffre. And she had to admit that she was not sent out to prime ministers, foreign presidents, excuse me. I believe on the prime minister account she said there was one and she held fast. But as far as foreign presidents went, she was asked 3 times if that had ever happened, and she said no each time. And then later on, her and her lawyers tried to change the deposition record, and by saying that she did not understand the question. And as Maxwell's defense attorneys had noted, she was asked the question 3 times, and the third time she said, "I've already told you no." So she was obviously understanding the question because she did not waver in her response any of those 3 times. That was one strike, another strike, I should say, against Giuffre. At the juncture in this proceedings, these lurid details are unnecessary to the determination of whether Jane Doe 3 and Jane Doe 4 should be permitted to join petitioner's claim that the government violated their rights under the CVRA. The factual details regarding with whom and where the Jane Does engaged in activities are immaterial and impertinent to this central claim. Those are the words I was looking for, immaterial and impertinent. Maxwell's defense attorneys brought that up several times in their filings that we read yesterday. To this central claim, i.e., that they were known victims of Mr. Epstein and the government owed them CVRA duties. especially considering that these details involve non-parties who are not related to the respondent government. These unnecessary details shall be stricken. The original Rule 21 motion shall be stricken in its entirety, as it is wholly superseded by the, quote, corrected version of the Rule 21 motion. From the corrected Rule 21 motion, the court shall strike all factual details regarding Jane Doe 3 between the following sentences. Quote, the government then concealed from Jane Doe number 3 the existence of its NPA from Jane Doe number 3 in violation of her rights under the CVRA, close quote, and the government was well aware of Jane Doe number 3 when it was negotiating the NPA, as it listed her as a victim in the attachment to the NPA. Close quote. As none of Jane Doe 4's factual details relate to non-parties, the court finds it unnecessary to strike the portion of the Rule 21 motion related to her circumstances. So it sounds like actually Jane Doe number 4 is in. Regarding the declaration in support of petitioner's response to Mr. Dershowitz's motion to intervene, the court shall strike paragraphs 4, 5, 7, 11, 13, 15, 19 through 53 and 59, as they contain impertinent details regarding non-parties. Regarding the declaration of Jane Doe 3 in support of the Rule 21 motion, the court shall strike paragraphs 7 through 12, 16, 39, and 49, as they contain impertinent details regarding non-parties. Jane Doe 3 is free to reassert these factual details through proper evidentiary proof, should petitioners demonstrate a good faith basis for believing that such details are pertinent to a matter presented for the court's consideration. I know they take a lot longer to get through, but I very much appreciate the way these pages are written versus how the testimony, the closed-door testimony that I've been reading previous to this, how those are formatted. Probably takes me 3 times as long to get through a page like this, but I stumble so much less often. It's fun. It's fun to read. This is terrible stuff, don't get me wrong. This is not fun reading, but at least I'm not stumbling so often that it becomes a problem. At least in my mind. You guys may feel differently. As mentioned, Mr. Dershowitz's moves to intervene, quote, for the limited purposes of moving to strike the outrageous and impertinent allegations made against him and requesting a show cause order to the attorneys that have made them. As the court has taken it upon itself to strike the impertinent factual details from the Rule 21 motion and related filings, the court concludes that Mr. Dershowitz's intervention in this case is unnecessary. Accordingly, his motion to intervene will be denied as moot. And here we've got a footnote right here that corresponds with that. This also moots Mr. Dershowitz's motion for leave to file supplemental reply in support of motion for limited intervention. Denying Mr. Dershowitz's motion to intervene also renders moot petitioner's motion to file a sealed document supporting its response to Mr. Dershowitz's motion. It will accordingly be denied as moot, and DE 293, the sealed response, will be stricken from the record. Back to the text. Regarding whether a show cause order should issue, the court finds that its actions of striking the lurid details from petitioner's submissions is sanction enough. However, the court cautions that all counselors subject to Rule 11's mandate that all submissions be presented for a proper purpose and factual contentions have evidentiary support, and that the court may, on its own, strike from any pleading, quote, any redundant, immaterial, impertinent, or scandalous matter, close quote. Paragraph B, Section B, Rule 15 motion. Between their two motions, the Rule 21 motion and Rule 15 motion, Jane Doe 3 and Jane Doe 4 assert that, quote, they desire to join in this action to vindicate their rights under the CVRA as well, close quote. Although petitioners already seek the invalidation of Mr. Epstein's non-prosecution agreement on behalf of all, quote, other similarly situated victims, close quote, Jane Doe 3 and Jane Doe 4 argue that they should be fellow travelers in this pursuit, lest they, quote, be forced to file a separate suit raising their claims, close quote, resulting in, quote, duplicative litigation. The court finds that justice does not require adding new parties this late in the proceedings who will raise claims that are admittedly duplicative of the claims already presented by petitioners. The Doe's submissions demonstrate that it is entirely unnecessary for Jane Doe 3 and Jane Doe 4 to proceed as parties in this action, rather than as fact witnesses available to offer relevant, admissible, and non-cumulative testimony. Jane Doe 3 and Jane Doe 4, quote, are in many respects similarly situated to the current victims, close quote. Also, the new victims will establish at trial that the government violated their CVRA rights in the same way as it violated the rights of other victims. That's a quote as well. And 10, Jane Doe 3 and Jane Doe 4, quote, will simply join in motions that the current victims were going to file in any event, close quote. 11, litigating Jane Doe 3 and Jane Doe 4's claims would be duplicative. There's a there's a quotation from a document put in as evidence. Quote, as promised, Jane Doe 3 and Jane Doe 4 do not speak to expand the number of pleadings filed in this case. If allowed to join this action, they would simply support the pleadings already being filed by Jane Doe 1 and Jane Doe 2. Another quote from evidence. Quote, all four victims, represented by the same legal counsel, intend to coordinate efforts and avoid duplicative pleadings, close quote. 15, Jane Doe 3 and Jane Doe 4, quote, challenge the same secret agreement, i.e. the NPA that the government executed with Epstein and then concealed from the victims. This is made clear by the proposed amendment itself, in which all four victims simply allege the same general facts, close quote. As the Does argue at length in their Rule 15 motion, Jane Doe 1's original petition, quote, specifically alleges that the government was violating not only her rights, but the rights of other similarly situated victims, close quote. The court fails to see why the addition of, quote, other similarly situated victims, close quote, is now necessary to, quote, vindicate their rights as well, close quote. Of course, Jane Doe 3 and Jane Doe 4 can participate in this litigated effort to vindicate the rights of similarly situated victims. There is no requirement that the evidentiary proof submitted in this case comes only from the named parties. Petitioners point out as much, noting that regardless of whether this court grants the Rule 15 motion, quote, they will call Jane Doe 3 as a witness at any trial, close quote. The necessary, quote, participation of Jane Doe 3 and Jane Doe 4 in this case can be satisfied by offering their properly supported and underscored relevant, admissible, and non-cumulative testimony as needed, whether through testimony at trial or affidavits submitted to support the relevancy of discovery requests. Petitioners do not contend that Jane Doe 3 and Jane Doe 4's quote, participation in this case, close quote, can only be achieved by listing them as parties. As it stands, under the original petition, the merits of this case will be decided based on a determination of whether the government violated the rights of Jane Doe 1, Jane Doe 2, and all others, quote, other similarly situated victims, close quote, under the CVRA. Jane Doe 3 and Jane Doe 4 may offer, underscored, relevant, admissible, and non-cumulative evidence that advances that determination, but their participation as listed parties is not necessary in that regard. There's a reference from a court case called Herring that says, District Court did not abuse its discretion by denying amendment where, quote, addition of more plaintiffs would not have affected the issues underlying the grant of summary judgment. Also, under Rule 15, courts have held that leave to amend to assert a claim already at issue in another lawsuit should not be granted if the same parties are involved, the same substantive, that's a tough word for me today, substantive claim is raised and the same relief is sought. As to Jane Doe 4, at least adding her as a party raises unnecessary questions about whether she is a proper party to this action. Okay, we've got two footnotes here are relevant to that. Footnote 5, which came in after the sentence, same relief is sought. This says the court expresses no opinion at this time whether any of the attestations made by Jane Doe 3 and Jane Doe 4 in support of their motion will be, and these are underscored again, relevant, admissible, and non-cumulative. And then footnote 6 here, after the sentence ending in, she is a proper party to this action, the government contends that Jane Doe 4 is not a true, quote, victim in this case because she was not known at the time the government negotiated the non-prosecution agreement, and accordingly she was not entitled to notification rights under the CVRA. Any, quote, duplicative litigation filed by Jane Doe 4 would necessarily raise the issue of whether she has standing under the CVRA under these circumstances. Okay, back to the text. Petitioners also admit that amending the petition to conform to the evidence by including references to the non-prosecution agreement itself is, quote, unnecessary, as, quote, the existing petition is broad enough to cover the developing evidence in this case, close quote. The court agrees, and it concludes that justice does not require amending the petition this late in the proceedings. And 3, conclusion. Accordingly, it is hereby, and this is in bold, ordered and adjudged as follows. The Rule 21 motion is denied. The Rule 15 motion is denied. Intervenor Dershowitz's motion for limited intervention and motion to leave to file supplemental reply in support of motion for limited intervention are denied as moot. Petitioner's motion to seal is denied as moot. The following materials are hereby stricken from the record. Now remember, so Jane Doe number 3 and Jane Doe number 4, we don't know who Jane Doe 4 is, but Jane Doe 3 is Virginia Robert Snee Giuffre. They're out of the joinder. Their joinder motion was dismissed. They don't get to come in to the CVRA claim filed by Jane Doe 1 and Jane Doe 2. At the same time, Jane Doe 1 and Jane Doe 2 had filed a motion to seal certain aspects of their case. I don't know how much. I didn't get that from this. But that was denied as moot as well. I believe because the things that they were wanting sealed are being stricken from the record. I think. Remember, not a lawyer here. I had one class in communications law back in college. That's it. I'm just going by context and what I'm reading out loud. So, the following materials are hereby stricken from the record. And these are certain entries into evidence that we've already gone over in the motion, or in this order. So what we have here then at the end is, again in bold, done and ordered in chambers at West Palm Beach County, Florida, this 6th day of April, 2015. Okay, this is the document that was sent out through Ross Gow, who runs Acuity Reputation, a public relations firm. The letter was the impetus of the letter was from Maxwell's attorney, Ghislaine Maxwell's attorney. I believe the name is like Bender, something like that. And this was a non-literal cease and desist order to the publications and reporters who were reporting on the allegations that Virginia Giuffre had placed in her motion that we just read. And they were reporting those. And the lawyer said to the PR guy, put this out. But in no way was the lawyer mentioned in any of this. And there's some litigation that we talked about yesterday that raises the question whether or not this could be considered legal communications or not. So let's just go ahead and read this again for the people who weren't here yesterday. Now you can see there are, it is sent to himself, Ross Acuity Gow, Acuity Reputation. So he sent the letter to himself, the email, and he copied Martin Robinson, P. Peachy, who was with the Independent. I'm sorry, Martin Robinson is with the Daily Mail Online. P. Peachy, who's with the Independent. Nick Summerland, who's with the Mirror. David Brown, who's with the Times. Nick Always, and Loann Pugh, who both work for the BBC. Now, they said that they could have sent this to as many as 29 people in total. But they only have records of these 6. Okay, here's a letter. And again, this was sent to these people as a non-literal cease and desist order. To whom it may concern, please find attached a quotable statement on behalf of Ms. Maxwell. No further communication will be provided by her on this matter. Thanks for your understanding. Best, Ross. Roscoe, Acuity Reputation. Jane Doe 3 is Virginia Roberts, also known as Virginia Giuffre, when she was being pimped out to Epstein. So not a new individual. The allegations made by Victoria Roberts, see that? This is so screwed up. He makes 3 solid mistakes in this piece of paper here. He calls Virginia Victoria in the very next sentence. That's where I got mixed up earlier today. He misspells Alan Dershowitz's name, and he misspells the word retold. This is supposed to be an official pronouncement by a professional. Not really solid work. So, the allegations made by Virginia Roberts against Ghislaine Maxwell are untrue. The original allegations are not new and have been fully responded to and shown to be untrue. Each time the story is retold, it changes with new salacious details about public figures and world leaders, and now it is alleged by Ms. Roberts that, it should be Mrs. Roberts, that Alan Dershowitz is involved in having relations with her, which he denies. Maybe I pulled it back in time, I don't know. Ms. Roberts' claims are obvious lies and should be treated as such and not publicized as news, as they are defamatory. This and the next use of the word lies opened up Maxwell to a defamation suit by Virginia Roberts nee Giuffre. That was mainly what we read yesterday. Ghislaine Maxwell's original response to the lies and defamatory claims remains the same. Maxwell strongly denies allegations of an unsavory nature which have appeared in the British press and elsewhere, and reserves her right to seek redress at the repetition of such old defamatory claims. That last phrase there was supposed to be the cease and desist phrase that the recipients of this email had to infer from that. So again, not a literal cease and desist order. Okay, so there's that. Now we're on to Exhibit G. I have no idea what this is. Okay, this is from Roscoe, or he's at least titled in this. In the Queen's Court of Justice, Queen's Bench Division, claim number CR 2016-624 between Virginia L. Giuffre and Ross Gow. See, now she's Giuffre, not Roberts. That's kind of weird. Virginia L. Giuffre is the applicant, and Ross Gow is the respondent. This is from the U.S. District Court, Southern District of New York, so U.S. DY, or U.S. DNY, sorry. And it lists Virginia L. Giuffre as the plaintiff versus Ghislaine Maxwell, the defendant. This is dated Friday, November 18, 2016. And this was taken at the Essex Chambers, 29 18 Chancery Lane, London, UK. The court reporter is Lisa Barrett, accredited real-time reporter. So this appears to be a deposition. I'm guessing here. No, Ross is not Maxwell's attorney. I believe. I think this is because I really don't know. Actually, Iron Slippers, I don't know why Gow's name is all over this. Because Maxwell is a defendant, so I just don't. Virginia is the applicant and Gow is the respondent. Now, I don't know enough legal information to know exactly what that refers to. Maybe that is British nomenclature, but I don't know. I'll shut up and just get on with it. This is a list of the defense. You've got Meredith Schultz appearing for the plaintiff, as well as David Turner. And then for Ghislaine Maxwell, you've got Laura Menninger, who we heard from earlier today. And then counsel for defendant Ross Neal Sutherland Gow, witness. Okay, so Gow is a witness. And then we've got Richard Spearman, Queen's Court, Philip Arden, Devonshire Solicitors, LLP. And the examiner is Alan Dyer from Temple, London. This is a deposition, and the examiner is what we would call, God, we've got a different name for that in the U.S. And I'm also wondering who the special master is. That would be the person in charge of the deposition. Maybe that's coming up. So there's an index here and an exhibit index. We don't need to go through all that. More of that. Okay, here we go. Proceedings. The videographer. Here begins video card number 1, volume 1, in the video deposition of Ross Gow. This is taken in the matter of Virginia Giuffre and Ross Gow. This is being heard in the High Court of Justice, Queen's Bench Division, Senior Master, claim number, yada yada. Today's date is November 18, 2016, yada yada. The video operator today is Philip Hill from DTI Court Reporting Solutions. The court reporter is Lisa Barrett from DTI Court Reporting Solutions. This video deposition is taking place at the Essex Chamber in London. I will now hand over the proceedings to the examiner. Thank you, sir. Mr. Dyer. Would counsel or lawyers present, please identify themselves for the record first. Schultz. I'm Meredith Schultz from Boise, Schiller and Flexner, LLP, appearing for the plaintiff, Ms. Virginia Giuffre. With me is my colleague, David Turner, also from Boise, Schiller and Flexner, LLP. Next. I'm Laura Menninger from Haddon, Morgan and Foreman on behalf of Ghislaine. Okay. We just had a significant jump here. We went from page 8 to page 30. So I don't know if this is because This is what is considered the relevant portion, but all that is cut out. I'm looking here, and I don't see page 9. So I apologize for that, but there's nothing we can do. Okay, so top of page 30 goes like this. It's a partial sentence. Worst objection or worst grounds for me. Dyer. I think questions of payment do not fall within the scope. Schultz. Okay. Are you currently retained by Ms. Maxwell for professional services? Answer. If I could go back to my previous answer, Ms. Maxwell is a project client and it's on a day rate. If so, for the sake of argument, between 2nd of January 2015 and the 1st of February 2016, we were quite busy answering these incoming calls, so there was quite a lot of work at that point in time. Recently, there's been no work. There's been no need because the press activity has died down. Our function is somewhat redundant. Question. Can you estimate the last time that you worked on this account at your day rate? It would have been in 2015, probably April, May, something like that. No invoices, no payment in 2016 from my recollection. Question by Ms. Schultz. Mr. Gao, I'm going to hand you another document. This is an Exhibit 3 marked for identification. Schultz. Point of procedure. I have only 3 copies of these documents for each of the remaining, so I've marked it as Exhibit 3, etc. Do you recognize this email? I do. Did you receive this email? I did, on New Year's Day 2015. Did you contact Ms. Maxwell after receiving this email? I did. Did you make any response to Mr. Ball in any form? I did. Can you tell me what response you made? Well, the response to Mr. Ball was part of a series of responses. Having spoken to my client within 24 hours or so, we got back to Mr. Ball with an agreed statement which went out to a number of media. When you say, quote, agreed statement, can you tell me more about what you mean? Who agreed to that statement? I need to give you some context, if I may, about that statement. So, this is on New Year's Day. I was in France, so the email time here of 21:46 in French time was 22:46, and I was getting up early the next morning to drive my family back from the south of France to England, which is a 14-hour journey, door to door. Can you imagine, just briefly, can you imagine being able to drive to the south of France and doing so in less than a day? Wouldn't that be fabulous? Go to wine country, go to Bordeaux, and chill. Man, that would be awesome. Except for one thing, it's Europe. And Europe is shot. Maybe the country's still good. Maybe the countryside is worth visiting. I would not go to any of the major cities in Europe now. So on the morning of back to the text. So on the morning of the 2nd of January, bearing in mind that Ms. Maxwell, I think, was in New York then, she was 5 hours behind. So there was quite a lot of sort of time difference between the various countries here. I sent her an email, I believe, saying, parsing this, forwarding this email to her saying, how do you wish to proceed? And then I was on the telephone. I had 2 telephones in the car. I received in excess of 30 phone calls from various media outlets on the 2nd of January, all asking for information about how Ms. Maxwell was looking to respond to the latest court filings, which were filed on the 30th of December, as I understand. They're talking about, I'm almost positive, they're talking about the part of the joinder motion that Virginia Giuffre was included in, and the statements that were made by her about Maxwell. And as I understand, and by towards close of play on the 2nd, I received an email forwarded by Ms. Maxwell containing a draft. That probably should say towards close of day, not close of play. I received an email forwarded by Ms. Maxwell containing a draft statement, which my understanding was the majority of which had been drafted by Mr. Barden. That's her lawyer's name, Barden. with a header along the lines of, quote, "This is the agreed statement," close quote, at the close of, again, day on the 2nd. So I had gone under the channel tunnel. Never call it the channel, by the way. That's incredibly derogatory. Okay, back to the text. And I was sitting on the other side, and that email, which my understanding was that it had been signed off by the client, effectively, was then sent out to a number of media, including Mr. Ball and various other UK newspapers. Question. Mr. Gao, when you say, oh no, it's repeated again, end of play and close of play, are you referring to sending the email that's Exhibit 2? Yes, I am. I have no idea what that means. My understanding is that it went to people other than those listed. Yes, that is, Mr. Dyer, just a sample. Witness, that is a sample. Everyone who effectively, well, the detail on this, I was driving, so my eldest son in the back had my BlackBerry and was trying to capture. It was a pretty chaotic day. Most people in the UK were on holiday. In fact, it was a holiday weekend. Our office was closed. My PA was on holiday, so my son was basically doing an internship in the back of the car, downloading the names of the callers from various media outlets, and so we had a list of those, so when I got to the car park at the end of the Eurotunnel thing in the UK, I had numerous names, so the email went out to a wide range of people. Welcome back, Ray. Welcome back. Wonderful to see you as always. Email went out to a wide range of people. Sorry, I really got distracted there. But the 30 or so calls I had is an aggregate number. So there might have been 5 calls from the BBC from different people. So the BBC would only write one story. There wouldn't be 5 versions of it. So 30 is an aggregate number. I don't know. The BBC might write 5 versions of it. Schultz. Okay, looking again at Exhibit 2. Could you please review the individuals or email addresses of the listed in the 2 and BCC portion? Yep, and this is the document that we read a little bit ago about saying that Giuffre had said lies, and that there should be no the media outlets that were repeating what Giuffre had said should stop doing that because Maxwell had a recourse available to her. That's what this is talking about. Listed in the 2 and BCC portion. Yep. Did you send this written statement to any other individuals or entities who are not listed in that portion? Within 24 hours of this, yes. A wider range of people, definitely. This was the initial. These are the most pressing ones who said they were going to write a story, whether they had. If I could just explain a bit more context again in the world of PR. When you are in the field, you're engaged, and you've got to prioritize who you spoke to, and whoever shouts the loudest usually gets responded to first. So the reason there are 2 BBC people there, for instance, is there's BBC Broadcast Radio and BBC TV. Sorry, Broadcast Radio and BBC TV. And they were coming from different angles for different stories. But there was a certain sense of urgency and immediacy. So the half a dozen or so here were the ones that we prioritized to deal with that night because they were publishing the next day or thereabouts. But for instance, we also spoke to the Daily Express. I can't remember the name of the gentleman there or the lady, but I remember that was early the next morning when we got on to other channels. Question. So you sent the statement to additional individuals on January 3rd. Not just on January 3rd. I mean, as we had an agreed statement there, and I do recall there is a typo in which this is Virginia and Victoria. Dude, that's not a typo. That's a serious mistake. There was a transposition there. Not a transposition. A transposition would be Veringia. That would be a transposition. Back to the text. So the original email went out with the typo because that was taken from the statement that I believe Mr. Barden was broadly the architect of, but forwarded by Ms. Maxwell. So I took that as a verbatim statement and sent it out. I reread it in the calm light of day the next morning. There was at least one typo on it, so I changed that and reached out again to these people, updating the typo, and sent it out to additional people. Schultz. Mr. Gao, I'm going to hand you another document. I'm going to mark this as Exhibit 4. Schultz. This is a document that is Bates labeled yada yada. Thank you. The top email on this document says, from Ross Gao. Did you send this email? I believe I did, yes. Did you send it to Ms. Maxwell? Yes. In the to field, when it says G Max, do you recognize that to be Ms. Maxwell's email address? I do. In the second paragraph of the email, it states, please advise how you wish to handle this. Did you receive a response from Ms. Maxwell? Answer. Bearing in mind I was driving all that day, I can't recall what the exact response was, but from memory, it was along the lines of she would get back to me with how she wished to proceed. Ms. Schultz. Okay. Mr. Gao, I'm going to hand you another document. I'm going to mark it as Exhibit 5. And we just jumped pages again, this time from page 36 to page 122. So again, I believe they're cutting into the parts where you have Gao discussing the letter that we read, the email that we read. So let's see what we've got here. It's page 122. It starts with a fragmented sentence. Quote, I'm quoting, had existing authorization to make statements on Ms. Maxwell's behalf due to the reauthorization letter. Is that correct? Answer. I believe that from the 2nd of January 2015, I had an ongoing reestablished authority to represent her within the parameters of the 2011-2015 press releases there or thereabouts. Schultz. Mr. Dyer, I have no further questions. Dyer, thank you. That concludes your deposition. The witness, thank you, sir. Dyer, thank you very much. Okay, this is the end of the deposition. We'll just read this here. Certificate of deponent, or deponent, I don't know how that's pronounced. I, Ross Neal Sutherland Gao, hereby certify that I have read the foregoing pages, numbered 1 through 122 of my deposition of testimony taken in these proceedings on this day, and with the exception of the changes listed on the next page and or corrections if I find them to be a true and accurate transcription thereof. Okay, what's this? Okay, this is the examiner's certificate. There's another deponent certificate. Here's the court reporter's certificate. Okay, wow. This is tough to read. This is a message forwarded from James Ball from The Guardian on January 1st regarding Ghislaine Maxwell. And it's sent to Ross Gao at Acuity Reputation. Dear Ross, I know you guys can't read this. I'll do my best. I'm writing to you as you have in the past represented Ghislaine Maxwell. As you are no doubt aware, fresh allegations have been leveled against Ms. Maxwell in new U.S. court filings made in Florida on 30 December, which some outlets have already been reported. I would urgently seek any comment on behalf of your client or notification of her new representation if you no longer act for her. Many thanks for your help, James. Okay, and this is Gao telling Ghislaine that he'd been heard from, that he heard from Ball. All right, here's Exhibit H in the filings. Still dealing with my gosh, I'm sorry, I blanked for a second. It's been a long couple days. Still regarding the defamation suit between Giuffre and Maxwell, and Giuffre is the originator of the suit against Maxwell. Let's just start again under the header. Pursuant to Federal Rules of Civil Procedure 26-33-34, plaintiff hereby serves her responses and objections to defendant's second set of discovery requests and serves her answers to defendant's requests for admission. I'll have to stop for a second. David Von Kettering says, you came up on YouTube again. Sunday we generally watch Jason Goodman at 3 Eastern till 5, sometimes longer. So you might take a break on that day. Let's see. That's 2 to 4 my time. Sure, I can do that. I can take a break. Absolutely. I'll make a note. Sunday stream break 2p to 4p. Okay. Got it. And David, if you're in the chat at that time, please feel free to say, hey, stop. I will not take it personally. Oh, Iron Slippers, you're welcome. You're welcome. This is not work to me, by the way. I enjoy this. I really do enjoy it. This computer, this amplifier, whatever, that's the work. I mean, you guys are totally worth it. If you guys weren't here, I would still do this, but it would not be as much fun because I would not be getting the engagement that I'm getting now. You guys are the best. And the more of you that come in, the happier I am to see you because the chat just gets better and better and better. So you guys feel free to bring in anyone you know because if they're anything like you, they're quality people and they will only add to the chat. So go for it. If you know, this Charles and Jason, I'm not familiar with them. If you guys don't mind, I may join you. So give me their accurate channel name so I can search them. And I'll do my best to join you. Laura, you're more than welcome. You're more than welcome. Sounds like a good time. So yeah, like I say, just give me the data that I need to search for their channel, and I will make every effort to be there Sunday. So the channel is Jason Goodman. Okay, I'm going to write that down. Jason Goodman. If you guys saw my handwriting right now, you would laugh. It is so horrible. I call it pre-tertiary syphilitic scrawl. I say it sums it up really well. Okay, so general objections. Defendant's discovery requests violate Rule 33, Federal Rule Civil, which provides a party may serve on any other party no more than 25 interrogatories, including all discrete subparts, end quote. In that defendant has served a total of 59 interrogatories in this case, including subparts, in violation of Rule 33. Ms. Giuffre objects to defendant's second set of discovery requests to the extent they seek information that is protected by any applicable privilege, including but not limited to attorney-client privilege, work product privilege, joint defense privilege, public interest privilege, and any other applicable privilege. Did we just skip pages? No, 71, 72. That's page 1. Yeah, we did skip pages. We went from page 1 to page 5. What is going on here? Okay. Fragmented sentence at the top of page 5. on hundreds, if not thousands, of matters, and collectively have well over 100 years of combined practice experience. Accordingly, a request that each of these attorneys list all communications with the media is facially overbroad. Additionally, Ms. Giuffre objects to this interrogatory because a response would cause Ms. Giuffre the incredible and undue burden of having to catalog literally hundreds of communications that she has already produced in this case. Moreover, Ms. Giuffre objects because this interrogatory calls for the production of documents that are irrelevant to this action and not reasonably calculated to lead to the discovery of admissible evidence. Communications with the media regarding cases that bear no relation to the subject matter of this case from decades in the past are facially invalid and not calculated to lead to the discovery of admissible evidence. Ms. Giuffre additionally objects to the extent that this interrogatory seeks the communications of her attorneys, any author, reporter, correspondent, columnist, writer, commentator, investigative journalist, photojournalist, newspaper person, freelance reporter, stringer, or any other employee of any media organization or independent consultant, as such interrogatory is overly broad and unduly burdensome. Furthermore, Ms. Giuffre is not obligated to produce anything currently in the possession of Defendant Maxwell or her attorneys. Okay, that took some effort. Notwithstanding such objections, Ms. Giuffre has already produced her responsive communications, which are found in documents, Bates labeled, etc., etc. Okay, now we're into paragraph 6. I don't know they were numbering the paragraphs. 6. Identify any, quote, false statements attributed to Ghislaine Maxwell, which were, quote, published globally, including within the Southern District of New York, close quote, as you contend in paragraph 9 of count 1 of your complaint, including A, the exact false statement, B, the date of its publication, C, the publishing entity and title of any publication containing the purportedly false statement, D, the URL or internet address for any internet version of such publication, and the nature of the publication, whether in print, internet, broadcast, or some other form of media. Response to interrogatory number 6. This is a huge footnote. Where does that come from? I don't see it. Anyway, we're going to have to read it. The response to interrogatory number 6. Ms. Giuffre objects because the information interrogatory above, italics, is in the possession of defendant who has failed to comply with her production obligations in this matter. I broke my rule from yesterday. And has failed to comply with her production obligations with this very subject matter. See document request number 17 from Ms. Giuffre's second request for production of documents to defendant Ghislaine Maxwell. There's the footnote. Okay, let's read it. Request number 17 stated, quote, stated, produce all documents concerning any statements made by you or on your behalf to the press or any other group or individual, including all draft statements concerning Ms. Giuffre by you, Roscoe, or any other individual from 2005 to the present, including the dates of any publications and, if published online, the Uniform Resource Identifier, URL. I thought that was location, not identifier. Interesting. Address. Guys, put the definition of, or the explanation of URL into the chat if you would please, and highlight it highlight my name so I can see it. I absolutely have no idea why they're using Uniform Resource Identifier, unless that's correct, and URL is a real screw-up way of designating it. To continue. In response, defendant stated, Ms. Maxwell objects to this request on the grounds that it is cumulative and duplicative. Ms. Maxwell also objects to this request to the extent it calls for information that exists within the public domain, the internet, or in public court records, and which are equally available to both parties and can be obtained from some other source that is more convenient, less burdensome, less expensive. Ms. Maxwell further objects to this request to the extent it seeks documents or information provided by the attorney-client privilege, the work product doctrine, or any other applicable privilege. Ms. Maxwell is not producing Ms. Maxwell is not producing documents that are available in the public domain. Ms. Maxwell has been unable to locate any additional documents responsive to this request. Iron Slippers Uniform Resource Locator. That's what I thought. I said location, but yeah, locator is actually what I was trying to dig out of my lizard brain. Excuse me just a second. Excuse me just 1 second. Okay, let's just say there was some bunching that needed to be corrected. Leave it at that. Okay, so to continue under response to interrogatory number 6. Maxwell has not produced all, quote, URL or internet addresses for any internet version of such publication, close quote, that she directed her agent, Roscoe, to send. Ms. Giffrey further objects because the information requested above is in the possession of defendant's agent, who caused the false statements to be issued to various media outlets. Ms. Giffrey has not had the opportunity to depose Maxwell's agent Roscoe, therefore this answer remains incomplete. Consequently, Ms. Giffrey reserves the right to modify and/or supplement her responses as information is largely in the possession of the defendant and her agent. Ms. Giffrey objects to this interrogatory in that it violates Rule 33 as its subparts, in combination with the other interrogatories, exceed the allowable 25 interrogatories. Ms. Giffrey objects to this request because it is in the public domain. Ms. Giffrey also objects in that it seeks information protected by the attorney-client work product privilege and any other applicable privilege stated in the general objections. Notwithstanding such objections, Ms. Giffrey has already produced documents responsive to this request. There's Bates' label here, and supplements to such responsive documents with the following list of publications. While the identification of an exhaustive responsive list would be unduly burdensome, in an attempt to make a good faith effort towards compliance, Ms. Giffrey provides the following examples, which are incomplete based on the aforementioned reasons. Okay, so here's the letter, the statement that we've read previously from Roscoe at the request of Maxwell's lawyer, Barden. So we don't have to read that again. Here are some URLs. Let's see, interviews or excerpts from her joinder request. They're published in the Telegraph, Express, Daily Mail, Huffington Post, Jewish News Online, Bolton News, New York Daily News, AOL, and AOL UK. And here's their names, etc. Okay, we sailed through that one. Where are we at here on time? Oh yeah, we still got another 40 minutes to go. 38. Okay, United States District Court of Southern District of New York. Virginia Giffrey, plaintiff versus Ghislaine Maxwell, defendant. This one is plaintiff's supplemental responses to defendant's interrogatories 6, 12, and 13. Pursuant to Federal Rules of Civil Procedure 26, 33, 34, plaintiff hereby serves her supplemental responses to defendant's interrogatories 6, 12, and 13. Objections. Plaintiff maintains and hereby incorporates by references all applicable objections, including both general objections and specific objections to individual interrogatories in her prior responses and objections served on defendant in these supplemental responses. Defendant's discovery requests violate Rule 33, etc., which provide, quote, a party may serve on any other party no more than 25 interrogatories, including all discrete subparts. In that, defendant has served a total of 59 interrogatories in this case, including subparts, in violation of Rule 33. This sounds very familiar. She may be arguing against answering 6, 12, and 13 here, or it may be, as it says plainly, supplemental responses. Not really sure what's going on here. To continue, Ms. Giuffre objects to defendant's discovery request to the extent they seek information that is protected by any applicable privilege, including but not limited to attorney-client privilege, work product privilege, and any other applicable privilege. Accordingly, due to the undue burden of individually logging responsive, privileged documents related to defendant's overly broad requests, plaintiff has employed categorical logging of such privileged responsive documents pursuant to Local Civil Rule 26.2c. Ms. Giuffre objects to the requests in that they seek to invade her privacy for the sole purpose of harassing and intimidating Ms. Giuffre, who was a minor victim of trafficking. Ms. Giuffre objects to the request to the extent that they are overly broad and unduly burdensome. Ms. Giuffre's responses to defendant's second set of discovery requests are being made after reasonable inquiry into the relevant facts and are based only upon the information and documentation that is presently known to her. Ms. Giuffre reserves the right to modify and/or supplement her responses. Ms. Giuffre has produced documents and information in response to these requests. Ms. Giuffre incorporates her above-listed general objections in the responses herein. Supplemental interrogatory responses. 6. Identify any, quote, false statements attributed to Ghislaine Maxwell, which were, quote, published globally, including within the Southern District of New York, and, quote, as you contend in paragraph 9 of Court 1 of your complaint, including A, the exact false statement, B, the date of its publication, C, the publishing entity and title of any publication containing the purportedly false statement, D, the URL or internet address for any internet version of such publication, and E, the nature of the publication, whether in print, internet, broadcast, or some other form of media. Man, this seems similar. In addition to her previous response, Ms. Giuffre supplements the response to include January 8, 2015, on the internet, The Sun, and she lists a URL for the article, and as you can read from the URL, the title is basically Prince Andrew's pal, Ghislaine, groped teen. 12. Identify any healthcare provider from whom you received any treatment for any physical, mental, or emotional condition, including addiction to alcohol, prescription, or illegal drugs, that you suffered from subsequent to the alleged defamation by Ghislaine Maxwell, including. Okay. This seems a little out of bounds. Isn't it a HIPAA violation to make someone disclose medical information like that? I'm a little familiar with HIPAA, having dealt with it on both sides, but this just seems to be a blatant violation. Alleged defamation by Ghislaine Maxwell, including A, the healthcare provider's name, address, and telephone number, B, the type of consultation, examination, or treatment provided, C, the dates you received consultation, examination, or treatment, D, whether such treatment was on an inpatient or outpatient basis, E, the medical expenses to date, F, whether health insurance or some other person or organization or entity has paid for the medical expenses, and G, for each such healthcare provider, please execute the medical and mental health records release attached hereto as Exhibit A. Supplemental response to interrogatory number 12. Ms. Giuffre objects to this interrogatory in that it is overbroad and not limited in scope to the medical information relating to the abuse she suffered from defendant and Jeffrey Epstein. Pursuant to the rules, if requested documents are not yielded in a, quote, reasonable inquiry, Ms. Giuffre is not obligated to expend all of her time and resources on a quest to gather medical files that are unknown to her or inaccessible after reasonable inquiry. Okay, there's a citation here from a, let's see, Meneses v. New York City Department of Transportation. We go from, and here's another jump. We go from page 4 to page 11. Okay, I'm just going to go through. This is a list of medical providers that Giuffre saw. I don't know if this is the entire list or not, but here we go. Medicare Australia, Dr. Wawa San, CVS Pharmacy, Dr. Timothy Hartwig, DO, Dr. James T. Nichols, MD, and Dr. Rodolfo Torres Jr., MD. And that is dated August 17, 2016. Let's see if I can read this footnote. Records from Medicare Australia are generally limited to 3 years. Ms. Giuffre is continuing to pursue additional records from prior to July 19, 2013 through their offices in Australia. Okay, here's another one. Ms. Giuffre has now identified Dr. Wawasan and Dr. Wasan to be the same provider to the best of her knowledge. She had previously listed both names in an abundance of caution before learning that Dr. Wasan was the same provider as Dr. Wawa-san. And if you're at all familiar with Cheech and Chong, Wawa means something very specific to you. I'll just have to say. Okay, we're on to Exhibit J. This is a declaration of Ghislaine Maxwell in the case that Virginia Giuffre brought against Ghislaine Maxwell. Declaration of Ghislaine Maxwell. 1. I, Ghislaine Maxwell, declare as follows. 1. I am the defendant in this action. 2. I have no control or authority over any media organizations, including those media organizations that published any part of a January 2015 statement issued on my behalf at the direction of my attorney, Philip Barden. That's the statement we've read several times already and has been referenced several times already. That is basically known as the January 2015 statement in all of the proceedings we've had so far. But that was the one issued by Gao at the urging, or at the direction, of Barden. 3. Neither I nor any agent acting on my behalf approved or participated in any activity of any media organization in its decision to publish or not to publish any part of the January 2015 statement. Okay, she says that's true, but she is Ghislaine Maxwell. Crying out loud, her dad was the media baron of the UK for some time. Not saying she did it, but she certainly had the means and motive to do it, and the opportunity. So, again, am I saying she did it? No. Is it possible? Hell yeah. I declare under penalty of perjury that the foregoing is true and correct, executed on January 6, 2017. Exhibit K. Same case. This is the declaration of Philip Barden. That's her attorney. I, Philip Barden, declare as follows. 1. I am a solicitor of the Senior Courts of England and Wales, based in London, England. I am submitting this declaration in support of Ghislaine Maxwell's motion for summary judgment in this action. 3. I am not authorized to and do not waive Ms. Maxwell's attorney-client privilege. 4. I have represented Ms. Maxwell since 2011, regarding the allegations made by plaintiff Virginia Giuffre as published in the United Kingdom. I continue to be retained in this regard. I am familiar generally with the subject matter of this action. 5. I first represented Ms. Maxwell in this matter over the weekend of 5 and 6 March 2011, about the time when various UK national newspapers, in hard copy and online, published numerous and provocative allegations made by the plaintiff, Virginia Giuffre, against Ms. Maxwell. The articles by Sharon Churcher were among those published in this time frame. And if you weren't here yesterday, Sharon Churcher is a journalist who interviewed Giuffre quite extensively and published a number of articles through various media organizations after her interviews with Giuffre. And to be totally fair, Giuffre earned about $160,000 through these various stories. Not saying that's bad, I'm just saying it for completeness. 6. I instructed British press agent Ross Gow to assist me in representing Ms. Maxwell. 7. I caused to be prepared a statement to respond to the articles that appeared in the British press over the weekend, March 5 and 6, 2011, and thereafter I directed Mr. Gow to distribute the statements to various media outlets that had published articles. 8. On December 30, 2014, Ms. Giuffre made numerous salacious and improper allegations against Ms. Maxwell in a joinder motion publicly filed in a civil case involving Jeffrey Epstein. Shortly afterward, the British media gained access to the motion and began inquiring about Ms. Maxwell's response. 9. I continued to represent Ms. Maxwell at that time, and I coordinated the response to the media. I again instructed Mr. Gow to assist me. 10. In liaison with Mr. Gow and my client on January 2, 2015, I prepared a further statement denying the allegations, and I instructed Mr. Gow to transmit it via emails to members of the British media who had made inquiry about plaintiff's allegations about Ms. Maxwell. Attached as Exhibit A1 is an email containing a true and correct copy of this statement. The statement was issued on my authority. Although it is possible others suggested or contributed content, I prepared the vast majority of the statement and ultimately approved and adopted all of the statement as my work. 11. As is evident from the timing and the typographical errors in the statement, I prepared the statement in haste. I was not in the office on 2nd January 2015, as it was the Friday immediately after New Year's Day, which is a public holiday. Most people took 2nd January off, and many businesses closed that day. I don't now recall where I was that day, but I was hard to reach, and that indicates I was out with my family. I therefore would have prepared the statement in a hurry. I recall that I wanted to get a statement out as a matter of urgency. All that, I'll forgive the retold misspelling, but the getting Dershowitz's name wrong and calling Virginia Giuffre Victoria 4 words later, that's a hell of a lot of haste, let's put it that way. 12. I recall that immediately after Ms. Giuffre's motion was filed, media representatives began contacting Mr. Gow and requesting Ms. Maxwell's response to Ms. Giuffre's allegations of criminal and other misconduct by Ms. Maxwell. I believed an immediate response was imperative, even though this was happening in the midst of the holidays in the United Kingdom. My communications with Mr. Gow and with Ms. Maxwell were sporadic, delayed, and hurried because of my and their own holiday schedules. I worked while on vacation, and on Friday, January 2, 2015, to ensure that the statement was issued as soon as possible after receiving the media inquiries. I did not ask Ms. Maxwell to respond point by point to Ms. Giuffre's factual allegations in the CVRA joinder motion. What we needed to do was issue an immediate denial, and that necessarily had to be short and to the point. It should have been obvious to the media that Ms. Giuffre's new and significantly more salacious allegations had no credibility because they differed so substantially from her previous allegations when she had the opportunity and incentive to disclose all relevant facts about being a victim of alleged abuse and trafficking at the hands of the rich and powerful. I prepared the January 2015 statement based on my knowledge of Ms. Giuffre's past statements and her most recent statements in the joinder motion, and made the point to the media recipients that she and her new statements, which differed so substantially from her former ones, were not credible, specifically that the new allegations were patently false, i.e., quote, obvious lies. 14. By way of example, I recall that prior to the December 2014 filing of the joinder motion and the subsequent press reports that Ms. Giuffre clearly stated she had not had relations with Prince Andrew. Yet in her joinder motion, she claimed she did have relations with Prince Andrew and that the relations occurred in what can only be described as a very small bathtub, too small for a man of Prince Andrew's size to enjoy a bath in, let alone relations. So as of December 2014, it was clear Ms. Giuffre had made polar opposite statements. She was either lying when she said they did not have relations or when she said they did. I made the inescapable inference that she is a liar, as clearly she is, since both statements cannot, as a matter of fact, be true. When someone says she did not have relations and then says she did, in other words, there is an obvious lie. Got to agree with that. 15. I did not intend the January 2015 statement as a traditional press release solely to disseminate information to the media. This is why I intentionally did not request that Mr. Gao or any other public relations specialist prepare or participate in preparing the statement. Instead, Mr. Gao served as my conduit to the media representatives who had requested a response to the joinder motion allegations and who I believe might republish those allegations. My question here is, why didn't you have your name included in the statement? It was your writing. You said yourself. You prepared it, the vast majority of it. Why wasn't your name included, Mr. Gardner? Why not? 16. My purpose in preparing and causing the statement to be disseminated to those media representatives was twofold. First, I wanted to mitigate the harm to Ms. Maxwell's reputation from the press republication of plaintiff's false allegations. I believe these ends could be accomplished by suggesting to the media that, among other things, they should subject plaintiff's allegations to inquiry and scrutiny. For example, I noted that plaintiff's allegations changed dramatically over time, suggesting that they are, quote, obvious lies and therefore should not be, quote, publicized as news. 17. Second, I intended the January 2015 statement to be a, quote, shot across the bow of the media, which I believed had been unduly eager to publish plaintiff's allegations without conducting any inquiry of their own. Dude, it's the British press. Come on. Come on. This was the purpose of repeatedly stating that plaintiff's allegations were, quote, defamatory. In this sense, the statement was very much intended as a cease and desist letter to the media recipients, letting the media recipients understand the seriousness with which Ms. Maxwell considered the publication of plaintiff's obviously false allegations and the legal indefensibility of their own conduct. Again, you did not say cease and desist as part of the letter. You said here you can quote Ms. Maxwell on this. Under that, you could have said, not for publication, cease and desist publishing these allegations, or you will be sued. Attorney for Ms. Maxwell, Philip Gander, or Gardner? I forgot already. Anyway, her attorney, signed her attorney. That would have solved everything. You wouldn't be in this position right now, for the most part. except you had to include lies and defamatory. Okay, Tiger's 2 under after 14, not good enough. Not good enough. He has to step it up tomorrow or he's not going to make the cut. 18. It is important to understand that any story involving a member of the royal family, especially a senior member such as Prince Andrew, gains huge media attention in the UK. Well, that was the point. And a story alleging he had a relation with the plaintiff caused a feeding frenzy for the press. I wanted the press to stop and think before publishing, to cease and desist. It's not what you said. And that if they continued, then they faced higher damages for ignoring my clear warning. Again, it's not what you said. You said Maxwell had further recourse. You did not definitively state what you were trying to convey. I'm sorry, to me that makes a terrible lawyer. 19. Consistent with these two purposes, Mr. Gao's emails prefaced the statement with the following language, quote, please find attached a, in italics, quotable statement, I know I broke my rule, on behalf of Ms. Maxwell, close quote. The statement was intended to be a single, one-time only, comprehensive response, quoted in full, if it was to be used, to plaintiff's December 30, 2014 allegations that would give the media Ms. Maxwell's response. The purpose of the prefatory statement was to inform the media recipients of this intent. Well, you did that right. 20. Selective and partial quotation and use of the statement would to serve my purposes. Yeah, but you didn't say, please use this in full, or, do not excerpt out of context, things like that. You could have made that clear, but you didn't as well. And again, we're talking about the British press. They're sharks. Put blood in the water, and they will go crazy. You can't expect them to infer your directions from fairly indistinct writing. Selective and partial quotation and use of the statement, this is 20, I'm starting over, would serve my purposes. It was intended to address plaintiff's behavior and allegations against Ms. Maxwell on a broad scale. That is to say, plaintiff's history of making false allegations and innuendo to the media against Ms. Maxwell. This is why the statement references plaintiff's, quote, original allegations and points out that her story, quote, changes, i.e., is embellished over time, including the allegations, quote, now, that Professor Dershowitz allegedly had relations with her. This is why I distinguish in the statement between plaintiff's, quote, original allegations and her, quote, new joinder motion allegations, which differed substantially from the original allegations. And this is why I wrote, each time the story is retold, it, okay, in italics here, changes with new salacious details about public figures and world leaders, and now it is alleged by plaintiff that Alan Dershowitz is involved in having relations with her, which he denies. Having established the dramatic difference between plaintiff's two sets of allegations, which suggested she was fabricating more and more salacious allegations as she had more time to manufacture them, I added the third paragraph, quote, Ms. Giuffre's claims are obvious lies and should be treated as such and not published as news as they are defamatory. I believed then and believe now that it was and remains a fair inference and conclusion that her claims were and are obvious lies, quote unquote. As noted, her claims to have not slept with Prince Andrew and to have slept with Prince Andrew are a classic example of an obvious lie. One or other account is, on the face of it, a lie. 21. As an example of her lack of credibility, the plaintiff made allegations against Professor Dershowitz, which I understand she has now withdrawn. Professor Dershowitz has credibility because his story, insofar as I am familiar with it, has been consistent. Ms. Giuffre has no credibility because her story has shifted and changed. Okay. She may have lied. Well, she did lie. Like it said, she either was with Andrew or she wasn't. That's fair. So one of those is a lie. Um, I don't think you would have a hard time remembering if that happened or not, especially the whole bathtub thing, which I had not heard before. Um, doesn't mean everything is a lie. It casts serious doubt on her credibility, to be sure. But is, I mean, the old thing on the stand. If you tell one lie, everything's a lie. Does that apply here? Do you have any sympathy for Ms. Giuffre? I personally do. But you can't take everything she says at face value, obviously. 22. Further, the plaintiff's account has become more salacious, for example, regarding Prince Andrew. The plaintiff clearly has been seeking publicity for her story, and it is clear to me that she understands retelling the same story doesn't feed the media and generate publicity, and so each time she appears to create new allegations to generate media interest. Well, that's a fair inference. 23. I understand the plaintiff alleged in her complaint in this action that the following statements are defamatory. She alleges it was defamatory in the first paragraph of the January 2015 statement to state that, quote, the allegations made by the plaintiff against Ms. Maxwell are untrue, close quote. For the reasons stated above, it was and is my considered and firm opinion that, in fact, her allegations are untrue. Now, but what proof do you have of that? She alleges it was defamatory to state in the same paragraph that the original, quote, original allegations have been, quote, shown to be untrue. For the reasons stated above, it was and is my considered and firm opinion that, in fact, her allegations are untrue. And again, we're dealing with an opinion. We're not dealing with facts. Finally, she alleges that it was defamatory in the third paragraph to state that her claims are, quote, obvious lies. For the reasons stated above, it was and is my considered and firm opinion that, in fact, her claims are obvious lies. Some are, but are all of them? You haven't proven that yet. 24. Both Mr. Gao and I understand that once the January 2015 statement... Oh, break. This is perfect timing. Thank you, Picasso Knows. I'm sorry I missed that earlier. Again, my lovely, talented, and intelligent executive producer comes through for me again. I'm so lucky to have her. So lucky to have her. And to be honest, she adds some nice things to the chat too. So I think she helps generate some good points. She certainly clears up any misconceptions or misstatements that I make well. So that adds to the charm to the media representatives. We had no ability to control whether or how they would use the statement, and we made no effort to control whether or how they would use the statement. Well, you're bitching and complaining that they didn't use it the way you wanted them to. So I guess that proves you didn't have any influence. So I guess you're off the hook on that. 25. It is my understanding that some of the media recipients of the January 2015 statement did not publish any part of the statement. I am unaware of any media recipient publishing the statement in full. 26. The issuance of the statement fully complied with my ethical obligations as a lawyer. Indeed, it was duty in representing my client's interests to ensure that a denial was immediately issued. I would have been remiss if I had sat back and not issued a denial, and the press had published that Ms. Maxwell had not responded to enquiries and had not denied the new allegations. The public might have taken the silence as an admission there was some truth in the allegations. 27. The content of the statement was entirely based on information I acquired in connection with my role as counsel for Ms. Maxwell. Excuse me just a second. Thank you. 28. At the time I directed the issuance of the statement, I was contemplating litigation against the press recipients as an additional means to mitigate and prevent harm to Ms. Maxwell. Whilst the limitation period for a pure defamation claim has now expired, claims are still being considered, for example, for publishing a deliberate falsehood, conspiracy to injure, and other tortious acts. 29. In any such UK defamation or other related action, Ms. Giuffre would be a defendant or a witness. 30. I directed that the statement indicate Ms. Maxwell, quote, strongly denied the allegations of an unsavory nature, close quote, declare the allegations to be false, give the press recipients notice that the publications of the allegations, quote, are defamatory, unquote, and inform them that Ms. Maxwell was, quote, reserving her right to seek redress, close quote. I declare under penalty of perjury that the foregoing is true and correct. Executed on January 6, 2016, Philip Barton. And there we have it. And coming up tomorrow is another deposition. This will be a deposition of James Michael Ostrich, which, if you weren't here yesterday, Ostrich was at one time a fiance of Virginia Giuffre, but she was actually at one time cheating on him, and ultimately went back with her previous boyfriend, one Anthony Figueroa, who was a complete piece of shit. And no one has said that Virginia Giuffre / Roberts has made a lot of great decisions in her life, that's for sure. So we will do that tomorrow. I'm going to write this down. This is page 227. Page 227. So you won't have to watch me screw around all day trying to find the right page. Okay, folks. It is 3:42 my time, and I'd hope to end at 3:45. So I'd say we've done a good job today. All things being considered. I did waste 2 hours. I shouldn't say waste, but I did cause an hour and a half of time to slip by this morning with probably about 15 minutes of dead air after YouTube cut us off. I apologize for not recognizing that sooner. Picasso noticed it right away, but I misunderstood what she was saying. And again, YouTube showed me as being live, and I believed that, which was incorrect. David, thank you so much. I really appreciate it. It's really kind of you, and I appreciate your being here. I know you're spending time watching Tiger struggle, which is a horrible thing to have to watch. I hate watching great golfers have a bad day. But we're good to go, folks. So I will see as many of you as possible tomorrow, starting at 11 a.m. I'm starting to lose my voice. At 11 a.m. We'll go probably till 7 Central, so that's a good 8 hours. And then Saturday I'm off, Sunday I'm on, with a break at 2 to 4 Central Time, where I'll join you with the on the Jason Goodman channel, and we'll get back onto it. So thank you all. Thank you for your nice thoughts, and I can't say how much I appreciate it. Basically it. So until tomorrow, be well. God bless. Happy trails. See you soon.
I hope I learned something. I hope I learned something. I hope I learned something from the story you see, from the brightest day, from the darkest night. sunny day. I hope you learn something. I hope you learn something. I hope you learn something from the stormy sea, from the brightest day, from the darkest nights, from the sunny hope we learn something. I hope we learn something. I hope we learn something from the stormy sea, from the brightest day, from the darkest night.